I knew the moment I saw Brenda Carmichael's silver Lexus pull into my driveway that my peaceful Saturday morning was about to be ruined. She didn't even bother parking properly, just left her car at an angle that blocked half my garage entrance and marched up to my front door like she owned the entire subdivision. My name is Brandon Stevens, and I had just moved into Clearwater Meadows in suburban Phoenix, Arizona 3 months ago, excited to finally own a home with enough space to install the renewable energy system I'd been dreaming about for years. The doorbell rang 3 times in rapid succession, each chime more aggressive than the last. I set down my coffee mug and opened the door to find Brenda standing there with her arms crossed. Her blonde highlighted hair pulled back so tight it looked painful, and her lips pressed into a thin line of disapproval. She was wearing what I'd come to recognize as the HOA president uniform, expensive athleisure wear, oversized sunglasses pushed up on her head, and a leather-bound binder clutched against her chest like a shield. "Mr. Stevens," she said, not bothering with pleasantries. "We need to discuss your recent property modifications immediately." I glanced past her at my front yard, where the solar panels I'd had installed on my roof gleamed in the Arizona sun, and the small wind turbine I'd erected near the back corner of my property spun lazily in the morning breeze. Next to my garage, I'd also installed a battery storage system housed in a sleek gray cabinet that matched my home's exterior. Everything had been professionally installed, properly permitted with the city, and was completely within my property boundaries. "Good morning to you too, Brenda," I said, keeping my tone neutral. "What seems to be the problem?" She flipped open her binder with such force I heard the rings snap. "What seems to be the problem? Brandon, your property looks like an industrial facility. Those panels are an eyesore. That ridiculous windmill is completely inappropriate for a residential neighborhood. And don't even get me started on that massive battery thing next to your garage. You're bringing down property values for the entire community." I'd been expecting this conversation ever since I'd started the installation process, so I'd done my homework. "Brenda, I made sure everything was properly permitted. The city inspector signed off on all of it. The solar panels are on my roof, which is my property. The wind turbine meets all setback requirements and noise ordinances. The battery system is no bigger than a standard AC unit, which plenty of neighbors have. I don't care about city permits," she snapped, flipping through pages in her binder. "The HOA has covenants, conditions, and restrictions that every homeowner agreed to when they purchased their property. You signed these documents, Brandon." Article 7, Section 3 clearly states that no structures may be erected without prior written approval from the Architectural Review Committee. You never submitted any plans to us. "Actually," I said, stepping back into my house and grabbing my own folder from the entry table, "I did submit plans. I sent them via certified mail to the HOA board 6 weeks before installation began. I have the receipt right here showing they were received and signed for by someone named Deanne at the HOA management office." Brenda's face flushed slightly, but she didn't back down. "Even if you did submit plans, which I have no record of, they certainly weren't approved. The committee would never have approved such unsightly equipment. You need to remove all of it immediately, or the HOA will be forced to take legal action." "On what grounds?" I asked, my patience starting to wear thin. "These are renewable energy systems, Brenda. They're protected under federal law. The Federal Energy Regulatory Commission has clear policies about this, and Arizona has specific statutes that prevent HOAs from prohibiting solar energy devices." She laughed, a sharp, humorless sound. "Oh, so now you're a lawyer." "Brandon, I've been president of this HOA for 8 years. I know what I'm talking about. You have 30 days to remove all of that equipment, or we'll file a lawsuit and place a lien on your property. And you'll be responsible for all legal fees. Brenda, I really don't want this to become a legal battle, I said, trying to find some common ground. These systems are helping me reduce my carbon footprint and save money on utilities. They're not hurting anyone. Can't we work something out? The only thing we're working out is a timeline for removal, she said, pulling out a formal-looking letter from her binder and thrusting it toward me. This is your official notice of violation. 30 days, Mr. Stevens. I suggest you call your installer and get them scheduled soon, because the fines start accruing after that deadline, and they're not cheap. She turned on her heel and stalked back to her Lexus, leaving me standing in my doorway holding the violation notice. I watched her drive away, then looked down at the letter. It was printed on official HOA letterhead and detailed multiple alleged violations: unauthorized structures, aesthetic violations, failure to obtain approval, and something called disruption of neighborhood harmony. The fine structure started at $500 per day after the 30-day cure period. I went back inside and immediately pulled up the documents on my computer. When I'd purchased the house, I'd read through the HOA covenants carefully, specifically looking for anything that might impact my plans for renewable energy. I'd found a vaguely worded section about architectural approval, but I'd also found Arizona Revised Statutes Section 3318-16, which specifically prohibited HOAs from banning solar energy devices. I'd assumed that would be the end of it, especially after I'd properly submitted my plans. The next morning, I drove to the HOA management office, which was located in a small strip mall about 10 minutes from the neighborhood. The office was cramped and cluttered, with filing cabinets lining the walls and stacks of papers on every available surface. A tired-looking woman in her 50s sat behind the desk, typing slowly on an ancient desktop computer. "Hi," I said, approaching the desk. "I'm Brandon Stevens from Clearwater Meadows. I'm trying to track down some documents I submitted to the HOA a few months ago." She looked up, pushing her glasses up her nose. "Deanne Morrison, what kind of documents?" "Plans for solar panel installation and renewable energy equipment. I sent them via certified mail, and according to the tracking, they were signed for here." Deanne frowned and started shuffling through papers on her desk. "When was this?" "Early March. About 6 weeks before I started installation in mid-April." She got up and walked over to one of the filing cabinets, pulling open drawers and rifling through folders. After several minutes, she pulled out a large manila envelope that had clearly been opened. "Is this it?" I looked at the envelope, which had my name and address on it, along with the certified mail label. "Yes, that's mine. Were those plans ever reviewed?" Deanne pulled out the contents: detailed architectural drawings, specifications for the solar panels and wind turbine, photos of similar installations, and my cover letter requesting approval. Everything was still in pristine condition, as if it had never been looked at. "I remember this now," Deanne said slowly. "It came in right before I went on vacation for 2 weeks. When I got back, I put it in Brenda's mailbox for the architectural committee to review. I assumed they'd handled it." "They clearly didn't," I said. "And now Brenda is threatening to sue me and fine me $500 a day for having equipment she claims was never approved." Diane's expression shifted from tired to worried. "That's not right. You followed procedure. You submitted everything you were supposed to submit. If the committee failed to review and respond, that's on them, not you." "Can you document that?" I asked. "I need proof that I submitted these plans properly and that they were received." She nodded and started making copies of everything, including the envelope with the certified mail label and her own log book that showed when she'd placed the documents in Brenda's committee mailbox. "This isn't the first time something like this has happened," she said quietly as the copier hummed. "Brenda has a habit of ignoring submissions she doesn't like and then claiming they were never properly filed." Armed with my documentation, I spent the next few days researching federal and state law. What I found was even more supportive of my position than I'd initially realized. The Energy Policy Act, various federal Energy Regulatory Commission orders, and Arizona's specific solar rights laws all created a strong framework protecting residential renewable energy installations. HOAs could impose reasonable restrictions on placement and appearance, but they couldn't outright prohibit such systems or make them economically unfeasible through excessive requirements. I drafted a detailed response to the HOA's violation notice, citing specific statutes and case law. I explained that I had properly submitted plans, that the HOA had failed to respond within any reasonable time frame, and that even if they had responded with a denial, such denial would likely be unenforceable under state and federal law. I sent the letter via certified mail to both Brenda personally and to the HOA management office. 2 weeks went by without any response. My renewable energy system was working beautifully. The solar panels were generating more than enough power for my daily needs, and on particularly sunny days, I was even selling excess power back to the grid. The wind turbine added supplementary power during the evening hours when the Arizona breeze picked up. My first electric bill after full installation was less than $20, compared to the $150 I'd been paying before. Then I came home from work one Wednesday evening to find a notice taped to my front door. It wasn't from Brenda this time. It was from a law firm, Hutchinson, Reeves and Associates, attorneys at law. The letter informed me that they represented the Clearwater Meadows Homeowners Association and that legal action was being initiated against me for multiple violations of the CC and Articus. I was being sued for immediate removal of all renewable energy equipment, payment of accumulated fines now totaling $7,000, and reimbursement of the HOA's legal fees. I sat down on my front steps and read through the letter 3 times. $7,000 in fines. I checked the violation notice Brenda had given me. It had been exactly 31 days. Even at $500 per day, that should only be $500 for the single day I was past the deadline. But according to this new letter, the HOA was claiming multiple separate violations, each with its own $500 daily fine. One for the solar panels, one for the wind turbine, one for the battery system, and one for alleged unauthorized electrical work, even though everything had been done by licensed professionals. I needed a lawyer. I spent that evening calling every attorney in the Phoenix area who specialized in HOA disputes or renewable energy law. Most were either too busy to take a new client or didn't feel qualified to handle the federal energy policy aspects of the case. Finally, I reached an attorney named Patricia Williams who had experience with both HOA law and environmental policy issues. "Come in tomorrow morning," she said after I explained my situation. "Bring every document you have, purchase agreement, HOA covenants, your installation plans, permits, the violation notices, everything. This sounds like a clear case of HOA overreach, but we need to build an airtight defense." Patricia's office was in a modern building in downtown Phoenix, with floor-to-ceiling windows that overlooked the city. She was in her early 40s, with dark hair pulled back in a professional bun and sharp, intelligent eyes that immediately put me at ease. I spread all my documents across her conference table, and she spent nearly an hour reviewing everything, making notes on her legal pad and occasionally taking photos of specific pages. "Okay," she finally said, sitting back in her chair. "Here's what we're dealing with. First, the good news. You have an extremely strong case. You properly submitted your plans. The HOA failed to respond. Arizona law explicitly protects solar installations. Federal policy supports renewable energy. The equipment is professionally installed and properly permitted. All of that works in your favor. And the bad news?" I asked. "The bad news is that Brenda Carmichael and this HOA board are either completely ignorant of the law or they're hoping you'll back down rather than fight. Either way, they've hired attorneys who are going to bill them by the hour, and those costs are coming out of the HOA's funds, which means your neighbor's dues are paying for this lawsuit. The other bad news is that even though we'll likely win, litigation takes time and money. Are you prepared for that?" "I don't want to remove my renewable energy system," I said firmly. "It's not just about the money I'm saving. It's about doing the right thing for the environment. And honestly, it's about the principle. Brenda can't just bully people into submission because she doesn't like how something looks." Patricia nodded approvingly. "Good. Then here's what we're going to do. First, I'm going to file a response to their lawsuit with a counterclaim. We're going to argue that the HOA's actions violate Arizona Revised Statutes Section 33-18-16, that they failed to follow their own procedures, and that they're attempting to impose restrictions that are preempted by federal energy policy. Second, I'm going to request an emergency hearing to prevent them from imposing any fines while the case is being litigated. Third, we're going to put the individual board members on notice that they may be personally liable for violating state law. Can they really be held personally liable?" I asked. "If they're acting in bad faith or in violation of clear statutory protections, yes," Patricia said. "HOA board members have some protections when they're acting reasonably within their authority, but those protections don't extend to willful violations of state law. We're going to make sure Brenda and her board understand the risks they're taking." Over the next several weeks, the legal battle intensified. Patricia filed our response and counterclaim, and the HOA's attorneys filed replies. We went to a preliminary hearing, where Patricia successfully argued for a temporary restraining order preventing the HOA from imposing any fines or taking any action against my property while the case was pending. The judge, a middle-aged man named Robert Hendricks, seemed skeptical of the HOA's arguments from the beginning. "Counselor," Judge Hendricks said to the HOA's attorney, a slick-looking man in an expensive suit named Derek Hutchinson, "can you explain to me how your client believes they can prohibit solar panels when Arizona law explicitly protects them?" Hutchinson shuffled his papers. "Your Honor, the HOA isn't seeking to prohibit solar panels outright. They're simply enforcing reasonable architectural standards that apply to all homeowners equally. Mr. Stevens failed to obtain approval before installation, which is a clear violation of the CC and Articus. Except that Mr. Stevens did submit plans for approval, and your client failed to respond," Patricia countered. "Furthermore, even if approval had been required, and even if my client had failed to seek it, Arizona law prohibits HOAs from using the approval process to effectively ban or unreasonably restrict solar energy devices. That's exactly what's happening here." Judge Hendricks granted our motion for the temporary restraining order and set a trial date for 2 months out. As we left the courthouse, I felt a surge of relief, but Patricia warned me not to get too comfortable. They're going to fight this hard, she said. And they're going to make your life in that neighborhood as difficult as possible. Document everything. If anyone from the HOA or the board approaches you, if you receive any communications, if anything suspicious happens, I want to know about it immediately. She was right. The next HOA board meeting was scheduled for the following Tuesday, and I decided to attend. The meetings were held in the community clubhouse, a decent-sized building near the neighborhood entrance that included a gym, a pool, and a meeting room. When I arrived, about 30 other homeowners were already there, sitting in folding chairs facing a long table where Brenda and 4 other board members sat. Brenda's eyes narrowed when she saw me enter, but she didn't say anything. I took a seat in the back row and waited for the meeting to start. The first 30 minutes were routine business, approving the previous meeting's minutes, discussing landscaping contracts, reviewing the budget. Then Brenda cleared her throat and pulled out a familiar-looking folder. Item 7 on tonight's agenda, she announced. Ongoing litigation regarding unauthorized property modifications. As many of you know, the HOA has been forced to take legal action against a homeowner who installed unsightly industrial equipment without proper approval. This lawsuit is costing the association significant money in legal fees, and we may need to assess a special assessment to all homeowners to cover these costs. A murmur went through the crowd. I raised my hand. Brenda ignored me and continued. The board wants to be clear that we're protecting all of you. If we allow one homeowner to violate our covenants, it opens the door for everyone to do whatever they want. And before you know it, our beautiful neighborhood will look like a junkyard. That's a complete misrepresentation of the situation, I said loudly, standing up. And you know it, Brenda. The room went silent. Everyone turned to look at me. Mr. Stevens, Brenda said coldly, you're out of order. If you want to speak, you need to wait for the public comment period. When is that? I asked. At the end of the meeting, she said. Now please sit down or I'll have you removed. I sat down, fuming. The meeting continued for another 45 minutes, covering various mundane topics. Finally, Brenda announced it was time for public comments. I immediately stood up and walked to the front of the room. 3 minutes, Brenda said, setting a timer on her phone. I turned to address the other homeowners. My name is Brandon Stevens, and I live on Maple Ridge Drive. Some of you may have noticed the solar panels on my roof and the small wind turbine on my property. Brenda just told you that I installed unauthorized industrial equipment and that your HOA fees might go up because of me. That's not the whole story. I pulled out copies of my documentation and held them up. I properly submitted detailed plans to the HOA for approval over 6 weeks before installation began. I have certified mail receipts proving they were received. The HOA never responded, never approved or denied the plans, just ignored them. I followed every city code, got all the proper permits, and hired licensed professionals. Everything I installed is legal and protected under Arizona state law and federal energy policy. Several homeowners were listening intently now, some leaning forward in their seats. Arizona Revised Statutes Section 33-18-16 explicitly prohibits HOAs from banning solar energy devices. I continued. The law recognizes that renewable energy is important for our environment and our economy. What Brenda isn't telling you is that the HOA is spending your money to fight a lawsuit they're almost certainly going to lose, all because she personally doesn't like how solar panels look. Time's up, Brenda snapped. Sit down, Mr. Stevens. But before I could move, another homeowner stood up, a woman in her 60s with gray hair. I'd like to hear more about this. I've been thinking about getting solar panels myself. Are you saying the HOA can't stop me? That's not what I'm saying at all, Brenda interjected. What I'm saying is that proper procedures must be followed. Mr. Stevens didn't follow procedures. I did follow procedures, I said. I have proof. Another homeowner stood, a younger man with glasses. I'm an attorney, though not one who practices HOA law. But I'm familiar with the solar rights statutes, and from what Brandon is describing, it sounds like the HOA is on pretty shaky legal ground here. Brenda, why didn't the board just approve his plans when he submitted them? Solar panels are common now. Half the houses in the new development across the highway have them. Brenda's face was getting red. The Architectural Review Committee has the right to maintain aesthetic standards. We can't have every house looking different with random equipment stuck all over them. My panels are on my roof, which is standard, I said. The wind turbine is in my backyard and barely visible from the street. The battery system looks like an air conditioning unit. None of this is random or unsightly. The meeting devolved into arguments after that, with various homeowners taking sides. Some agreed with Brenda that maintaining uniformity was important. Others thought the HOA was wasting money on a pointless fight. A few were interested in renewable energy themselves and wanted to know more about the legal protections. Eventually, Brenda called for order and abruptly adjourned the meeting, gathering her papers and practically fleeing from the room with the other board members. As homeowners filed out, several people approached me to ask questions or express support. The woman who had spoken up first, who introduced herself as Margaret Chen, told me she'd been on the fence about solar panels, but was now definitely going to get them installed. The attorney, whose name was Daniel Frost, gave me his card and offered to be a witness if needed, since he'd attended board meetings where Brenda had made questionable legal claims before. I drove home feeling cautiously optimistic. At least now some of the other homeowners knew the truth. But that optimism was short-lived. 2 days later, I received another notice from the HOA. I was being fined $250 for disruptive behavior at a board meeting, and warned that any further disruptions would result in additional fines and potential suspension of community privileges. I immediately forwarded the notice to Patricia, who called me within an hour. This is retaliation, plain and simple. They're trying to punish you for speaking out. We're going to add this to our counterclaim. This actually helps our case because it shows the HOA is acting in bad faith. The trial date was now 6 weeks away, and both sides were deep into discovery. Patricia had subpoenaed all HOA records related to architectural approvals for the past 5 years, and what she found was illuminating. The HOA had approved numerous modifications to properties: pools, gazebos, outdoor kitchens, elaborate landscaping. In many cases, the approvals had been granted within days of submission. In some cases, homeowners had started work before receiving formal approval and had been granted retroactive approval without any fines or legal action. "This is exactly what we need," Patricia said, showing me the records. "We can prove that the HOA has been inconsistent and arbitrary in enforcement. They've bent over backward to approve modifications they liked while stonewalling yours. That demonstrates discriminatory enforcement, which is going to look very bad for them in court." Meanwhile, my renewable energy system continued to perform flawlessly. My second month's electric bill was even lower than the first, just under $15. Several neighbors had stopped by to ask about my setup, and I'd given informal tours of the equipment. Margaret Chen had indeed gotten solar panels installed, and when she submitted her plans to the HOA, they sat on them for weeks without responding. She called me for Patricia's contact information, and Patricia sent a stern letter to the HOA on Margaret's behalf. Within 3 days, Margaret's plans were approved. "They're scared now," Patricia explained. "They know they messed up with your case and they don't want another lawsuit, but that doesn't mean they're going to back down from the fight with you. If anything, they're probably more determined to win because if they lose, it sets a precedent that undermines their authority." As the trial date approached, the HOA made one last attempt to settle. Derek Hutchinson called Patricia with an offer. The HOA would drop the lawsuit and waive all fines if I agreed to relocate the wind turbine to a different position on my property, where it would be less visible from the street and add screening around the battery system. What do you think? I asked Patricia when she relayed the offer. "It's up to you," she said. "We have a strong case, but litigation is always risky. You never know what a judge might do. The settlement would save you the stress and uncertainty of trial. On the other hand, the requested changes would cost you money, and it feels like rewarding bad behavior. You did nothing wrong." I thought about it for a full day before making my decision. No settlement. The wind turbine is positioned exactly where it needs to be for optimal wind capture based on professional analysis. Moving it would reduce its efficiency. And the battery system doesn't need screening because there's nothing wrong with how it looks. This isn't about reasonable compromise. This is about Brenda trying to save face after realizing she screwed up. We're going to trial. The trial began on a hot Monday morning in late July. Judge Hendrick's courtroom was smaller than I'd expected, with wood paneling and fluorescent lights that gave everything a slightly yellow tinge. Patricia and I sat at one table. Derek Hutchinson and another attorney from his firm sat at the other, and Brenda was there as the HOA's representative. The HOA presented their case first. Hutchinson called Brenda to the stand, and she testified that the architectural review process was essential to maintaining property values and neighborhood aesthetics. She claimed that I had never properly submitted plans, or if I had, they had been submitted incorrectly. She insisted that the equipment on my property was industrial scale, unsightly, and negatively impacting surrounding home values. During cross-examination, Patricia methodically destroyed Brenda's testimony. She presented the certified mail receipt showing plans had been delivered and signed for. She showed the HOA's own records documenting that Diane had logged the plans and placed them in the Architectural Committee's mailbox. She presented photos of my equipment showing it was residential scale and professionally installed. Then she dropped the hammer. "Mrs. Carmichael," Patricia said, "I'm showing you Exhibit 17, which is the architectural approval for 2847 Willowbrook Court, dated March 15th of this year. This approval was for a 2-story pool house with a wet bar and outdoor kitchen. Can you confirm this is accurate?" Brenda glanced at the document. "Yes, that's accurate. And how long did it take the Architectural Committee to approve this modification after the plans were submitted?" "I don't recall exactly. According to the records, it was 4 days. 4 days to approve a 2-story structure with plumbing and electrical work. Now, Mr. Stevens submitted his plans on March 8th, nearly 2 months before installation began in mid-April. That's 67 days. Can you explain why a simple solar panel installation required more than 15 times as long to review as a 2-story pool house?" "Each application is different," Brenda said defensively. "Some are more complex than others." "Really?" "Because Mr. Stevens provided detailed specifications, professional drawings, photos of comparable installations, and permit applications. What additional information could the committee possibly have needed that would justify a 67-day review period with zero communication to the homeowner?" Brenda didn't have a good answer. She fumbled through several non-responsive explanations before Judge Hendricks told her to answer the question directly. "We had concerns about the visual impact," she finally admitted. "So you did review the plans?" Patricia pounced. "I saw them briefly, yes." "But you never approved them, never denied them, never communicated with Mr. Stevens in any way until after the installation was complete. The committee needed more time to consider them. 2 months wasn't enough time. Mrs. Carmichael, isn't it true that you simply didn't want to approve solar panels because you personally find them unattractive, and so you ignored Mr. Stevens' properly submitted application hoping he would give up?" "That's not true," Brenda said, but her voice lacked conviction. Patricia continued to hammer away, showing example after example of the HOA approving modifications quickly while stonewalling mine. She presented testimony from Diane Morrison, confirming that my plans had been properly submitted and handled according to standard procedures. She called an expert witness, a real estate appraiser, who testified that residential solar panels typically increase property values rather than decrease them. She called the installer who had done my work, who confirmed everything was code compliant and professionally done. Then it was our turn to present our affirmative case. Patricia walked Judge Hendricks through the relevant statutes, starting with Arizona Revised Statutes Section 3318-16. She read the key provisions aloud. "A covenant, restriction, or condition contained in any deed, contract, security instrument, or other instrument affecting the transfer, sale of, or any interest in real property that effectively prohibits or unreasonably restricts the installation or use of a solar energy device is void and unenforceable." "Your Honor," Patricia argued, "the statute couldn't be clearer. The Arizona legislature has made a policy decision that promoting solar energy is more important than HOA aesthetic preferences. Even if the Clearwater Meadows HOA had explicitly denied Mr. Stevens' application, such denial would be unenforceable under this statute. The fact that they simply ignored his application and then tried to force removal after installation makes their actions even more egregious." She moved on to federal policy, citing the Energy Policy Act and various FERC orders that encouraged residential renewable energy. While these federal laws didn't directly preempt HOA restrictions the way the state statute did, they established a clear national policy in favor of renewable energy that courts should consider when interpreting ambiguous contractual provisions. Derek Hutchinson tried to argue that the case was simply about following procedures and that the HOA had the right to enforce its covenants. But under Patricia's relentless cross-examination and Judge Hendricks' increasingly pointed questions, his arguments fell apart. The judge clearly understood that this wasn't about procedures. It was about an HOA board trying to enforce personal preferences in violation of state law. The trial lasted 3 days. On the afternoon of the 3rd day, after closing arguments, Judge Hendricks announced he would issue a written ruling within 2 weeks. Patricia and I walked out of the courthouse feeling good about our chances, but knowing that nothing was certain until we had the judge's decision in hand. The wait was agonizing. I tried to focus on work and normal life, but I found myself constantly checking my email and phone for updates. My neighbors in Clearwater Meadows were watching the case closely too. Margaret Chen kept me updated on the neighborhood gossip. Apparently, the community was divided, with a growing faction questioning Brenda's leadership and decision to pursue expensive litigation over solar panels. 12 days after trial ended, Patricia called me. "We won. Completely. Judge Hendricks just issued his ruling, and it's even better than I hoped. I'm emailing you a copy now." I pulled up the email on my computer and started reading. The ruling was 23 pages long and methodical in its analysis. Judge Hendricks found that I had properly submitted plans for architectural review, that the HOA had failed to respond within any reasonable time frame, and that even if they had denied my plans, such denial would have been unenforceable under Arizona Revised Statutes, Section 33-1816. He found that the HOA's attempt to impose fines was improper and ordered them to cease all enforcement actions related to my renewable energy equipment. But then the ruling went further. Judge Hendricks found that the HOA board had acted in bad faith by ignoring my properly submitted plans, retaliating against me for speaking at a board meeting, and pursuing meritless litigation, despite clear statutory protections for solar energy devices. He ordered the HOA to pay my attorney's fees and costs, which Patricia estimated would be around $40,000. He also issued an injunction preventing the HOA from interfering with any homeowner's installation of solar energy devices, unless the HOA could demonstrate that the proposed installation violated specific, reasonable aesthetic guidelines that had been clearly communicated in advance and applied consistently to all homeowners. I called Patricia back, barely able to contain my excitement. "This is incredible. Thank you so much for all your work on this. You deserve to win," she said. "You did everything right and they tried to bully you anyway. I'm just glad Judge Hendricks saw through their nonsense. Now, we need to talk about what happens next. The HOA will probably appeal, but they're going to have a hard time finding grounds given how thorough this ruling is. In the meantime, the ruling is effective immediately, so you don't have to worry about any more harassment about your equipment." "What about Brenda? Is there any accountability for her personally?" "The ruling doesn't impose personal liability, but she's going to have to explain to the other homeowners why their HOA fees are going to pay $40,000 in legal bills for a lawsuit they shouldn't have brought in the first place. That might be accountability enough." Word of the ruling spread through Clearwater Meadows within hours. Several neighbors called or stopped by to congratulate me. Margaret Chen brought over a bottle of wine to celebrate. Even some homeowners who had initially sided with the HOA admitted that Judge Hendricks' ruling had changed their perspective. The next HOA board meeting was scheduled for 2 weeks after the ruling. The meeting room was packed, with every chair filled and people standing along the walls. I arrived early and sat in the front row. Brenda and the other board members looked uncomfortable as they took their seats at the table. Before Brenda could even call the meeting to order, a homeowner stood up. It was Daniel Frost, the attorney who had supported me at the previous meeting. "I move for a vote of no confidence in the current board leadership, specifically President Brenda Carmichael, for gross mismanagement of HOA funds and pursuing meritless litigation that has cost this association $40,000. The room erupted in discussion. Brenda banged her gavel, calling for order. "That's not a proper motion. You can't just stand up and call for a vote of no confidence." "Actually," Daniel said calmly, "according to the HOA bylaws, any homeowner can make a motion at a board meeting, and if 20% of homeowners present second it, the board must vote on it. I've counted 42 people in this room. We need 8 seconds. Hands shot up all over the room. Daniel counted them off. 9, 10, 11. The motion is properly seconded. The board needs to vote. Brenda looked panicked. The other 4 board members looked at each other uncertainly. Finally, one of them, a quiet man in his 70s named Harold, spoke up. "I second Daniel's motion." "Brenda, I've gone along with a lot of your decisions over the years, but this solar panel lawsuit was a disaster. Brandon was right, we were wrong, and now everyone in this neighborhood is going to pay for your stubbornness. I think it's time for new leadership." Another board member, a woman named Susan, nodded. "I agree. I voted against filing the lawsuit in the first place, but Brenda insisted. I think we need to seriously reconsider who's leading this board." Brenda stood up, her face flushed. "After everything I've done for this community, this is how you treat me. Fine, I resign. You can deal with this mess yourselves." She grabbed her things and stormed out of the meeting room. The room sat in stunned silence for a moment. Then Harold cleared his throat. "Well, I guess we need to elect a new president. As the longest-serving board member after Brenda, I'll temporarily chair this meeting. Do we have nominations?" Margaret Chen stood up. "I nominate Brandon Stevens." I immediately shook my head. "Thank you, but no. I just moved here a few months ago, and I've been at war with the board that whole time. I don't think I'm the right person to heal this community." "Then what about Daniel?" someone else called out. "He's been here for years. He's an attorney, and he's been trying to bring some sanity to this board for a while." Daniel considered for a moment, then nodded. "I'll do it, but only if we make some serious changes to how this HOA operates. No more arbitrary enforcement. Clear, written guidelines for architectural review, transparency in decision-making, and recognition that times are changing. Solar panels, electric vehicle chargers, and other green technology are going to become more common, and we need to embrace that rather than fight it." There was a vote, and Daniel was elected president by an overwhelming margin. Over the next few weeks, the board went through a complete transformation. They adopted new architectural guidelines that explicitly welcomed solar energy devices and other renewable technology, with only minimal and reasonable restrictions on placement to address genuine aesthetic concerns. They implemented a 30-day approval deadline for all architectural applications, with automatic approval if the committee failed to respond within that time frame. The HOA decided not to appeal Judge Hendrick's ruling, recognizing that it would only waste more money on a losing cause. They sent a formal letter of apology to me, acknowledging that I had been treated unfairly and thanking me for my patience during the dispute. They even asked if I would be willing to present to other homeowners about the benefits of renewable energy and how to navigate the installation process. I agreed to give the presentation, which took place on a pleasant evening in early September. About 50 homeowners showed up, filling the community clubhouse meeting room. I walked them through my experience, showing them how much money I was saving on electric bills, explaining the environmental benefits, and discussing the various federal and state incentives available for renewable energy installations. "The upfront cost can seem daunting," I explained, showing a slide with installation costs. "My complete system, including solar panels, wind turbine, and battery storage, cost about $35,000 before incentives. But with the federal solar investment tax credit, which gives you back 26% of the cost, plus Arizona state incentives, I'm getting back about $12,000. That brings my net cost down to $23,000. I clicked to the next slide. "Based on my current electric bill savings, the system will pay for itself in about 8 years. And solar panels typically last 25 to 30 years, which means I'll have nearly 2 decades of essentially free electricity after the payback period. Plus, my home value has increased." The appraiser who testified at trial said solar homes in Arizona sell for an average of $15,000 more than comparable homes without solar. The homeowners asked thoughtful questions about different types of systems, whether wind turbines were necessary, how batteries worked, and what happened if equipment needed repairs. I answered everything as best I could and gave them contact information for my installer, who had done excellent work. Over the following months, 7 more homes in Clearwater Meadows installed solar panels. Margaret Chen went even further than I had, adding enough panels to make her home net zero energy, meaning she generated as much power as she consumed over the course of a year. The neighborhood was changing, becoming more environmentally conscious, and it felt good to have played a part in that transformation. One afternoon in early November, I was out front checking on my system when a car pulled up, and a woman I didn't recognize got out. She was in her 30s, professionally dressed, with a laptop bag over her shoulder. "Brandon Stevens?" she asked. "That's me. I'm Jennifer Martinez from the Arizona Republic. I'm doing a story about HOA disputes over renewable energy, and your case keeps coming up as a major precedent. Would you be willing to talk to me?" I invited her in, and we spent an hour discussing the entire saga. She took notes and photos of my equipment. The article ran the following Sunday on the front page of the local section, with the headline, "Solar Power Showdown. Homeowners' Victory Over HOA Highlights Changing Energy Landscape." The article detailed my case and quoted Patricia explaining the legal protections for solar energy in Arizona. It also mentioned the broader trend of conflicts between homeowners wanting to install renewable energy and HOAs trying to maintain aesthetic uniformity. Patricia was quoted saying that my case would likely make HOAs across Arizona reconsider their approach to renewable energy, since fighting homeowners in court was expensive, and they usually lost. The article generated significant attention. I received emails and calls from homeowners in other communities facing similar issues. Patricia got several new clients, and the Arizona State Legislature even began discussing legislation to further strengthen solar rights, potentially limiting HOA's ability to impose even reasonable restrictions on panel placement. But perhaps the most satisfying outcome happened in late December. I was doing some holiday shopping when I ran into Brenda Carmichael in a Target parking lot. We made eye contact, and for a moment I thought she might just get in her car and leave. Instead, she walked over to me. "Brandon," she said stiffly, "I wanted to say that I'm sorry for how things went. I was wrong about the solar panel issue. I was thinking about it from an aesthetic perspective and didn't fully consider the legal and environmental aspects. You were right to fight back. I was genuinely surprised. Thank you for saying that, Brenda. I know it probably wasn't easy." "It wasn't," she admitted. "I spent 8 years as HOA president thinking I was protecting property values and keeping the neighborhood nice. After everything that happened, I realized I'd become too controlling, too rigid. I lost perspective on what really matters. Anyway, your system looks nice. I've driven by your house several times and it's really not intrusive at all. I was making a big deal out of nothing." "I appreciate you saying that," I said. "For what it's worth, I know you were trying to do what you thought was best for the community. We just disagreed about methods." We parted on civil terms, and I drove home feeling like the whole saga had finally reached a true resolution. The legal battle was won. The community had changed its approach, and even my adversary had come around to acknowledging that renewable energy wasn't the neighborhood-destroying threat she'd imagined. As I pulled into my driveway that evening, the sun was setting behind my house, casting long shadows across the yard. My solar panels gleamed on the roof, the wind turbine spun gently in the breeze, and the battery system hummed quietly next to the garage, storing energy for the night ahead. Everything was working exactly as it should, generating clean power, saving me money, and proving that environmental responsibility and suburban homeownership could coexist perfectly well. I went inside and checked my solar system's monitoring app, which showed I generated 42 kilowatt-hours of electricity that day while consuming only 31. The excess had been sold back to the grid, earning me a small credit. Over the past 8 months since installation, I generated enough power to fully cover my home's electricity needs, and then some. The following spring, Daniel Frost called me with news. The HOA board has been discussing creating a community solar program. We're exploring the possibility of installing panels on the clubhouse roof and maybe some ground-mounted arrays in the common areas. The power generated would offset common area electricity costs, which would help keep HOA dues lower. We'd love your input on the feasibility. I met with Daniel and the rest of the board, along with several renewable energy contractors. We developed a comprehensive plan for a community solar installation that would generate enough power for all the common area needs: the clubhouse, pool pumps, street lights, and landscape lighting. The system would cost about $60,000, but would pay for itself in just over 7 years through reduced electricity bills. The board voted unanimously to move forward. The community solar project was completed in July, exactly 1 year after my legal victory. The HOA held a ribbon-cutting ceremony, and nearly 100 homeowners attended. Daniel gave a speech about how the neighborhood had transformed from a community fighting over renewable energy to a community embracing it. He specifically thanked me for standing up for what was right and for educating the community about the benefits of solar power. A year ago, we had one home with solar panels, and that home's owner was facing a lawsuit, Daniel said. Today, we have 9 homes with solar, a community solar installation that will save us all money, and a reputation as one of the most environmentally progressive neighborhoods in Phoenix. That transformation happened because Brandon Stevens had the courage to fight back against unjust restrictions and the persistence to see it through. Brandon, thank you. The crowd applauded, and I felt a genuine sense of pride and accomplishment. What had started as a frustrating conflict with an overbearing HOA president had become something much more meaningful. A catalyst for positive change that would benefit everyone in the community for years to come. As the evening wound down and neighbors mingled around the newly installed solar panels, I reflected on everything that had happened. The fight hadn't been easy. There had been stress, uncertainty, legal bills, and countless hours spent on documentation and court proceedings. But it had been worth it, not just for me, but for Margaret Chen and the other homeowners who now had solar panels on their homes, for future homeowners who would benefit from clear, fair guidelines, for the environment, which benefited from every kilowatt-hour of clean energy we generated, and for the principle that homeowners shouldn't have to sacrifice their values or their rights just because a board member had different aesthetic preferences. Later that night, I sat on my back deck watching the stars come out, listening to the gentle whir of my wind turbine catching the evening breeze. My phone buzzed with a text from Patricia. Saw the photos of the ribbon cutting on Facebook. Congratulations on everything you've accomplished. You turned a legal victory into a community transformation. That's rare and special. I smiled and typed back. Couldn't have done it without you. Thanks for being willing to take on the case when others wouldn't. As I sat there in the gathering darkness, my home powered by energy I'd captured from the sun and wind, I thought about how much had changed in just over a year. Brenda's aggressive violation notice seemed like something from a different lifetime. The HOA that had once threatened to fine me $500 per day now featured community solar panels prominently in their marketing materials for prospective homebuyers. The neighborhood that had been divided over renewable energy now had regular meetings where homeowners shared information about the latest green technology. Most importantly, I'd learned that standing up for what's right, even when it's difficult and expensive, can lead to outcomes more positive than you ever imagined. Federal energy policy and state solar rights laws had protected my renewable energy system, but it was the willingness to fight for those protections that had made all the difference. Brenda had demanded I hide my renewable energy equipment, threatening legal action and financial ruin if I didn't comply. Instead, I'd stood my ground, knowing the law was on my side, and in doing so had helped create a community that embraced sustainability rather than fearing it. The wind turbine continued its steady rotation. The solar panels sat silent and ready for tomorrow's sunrise, and the battery system stored enough power to get me through the night. Everything was exactly as it should be, and I knew that the fight had been worth every moment of stress and uncertainty. Sometimes the most important victories aren't just about winning a legal case. They're about changing hearts and minds and creating a better future for everyone.